Hey, good afternoon, everyone. Do you own a home or have family members that own a home? Today, we're going to discuss the top 10 reasons why every homeowner needs an estate plan. I'm Hector Aguilar with eXp Realty, and I want to welcome you today to today's podcast. Today, we have the privilege to feature one of our very own, an attorney, Liz Apodaca of My Attorney LA and OC, who is going to help us understand why it's so important to have an estate plan commonly known as a living trust. Hi, Liz.
Hi, Hector. Glad to
How you
be
doing?
here. Thank you so much.
Thank you. I appreciate you taking the time and carving out some time out of your busy schedule to join us, because I know that you're constantly busy. You're in and out of court. You're always meeting with clients. So thank you for making the time to be
You're
with
welcome.
us.
My pleasure.
I think that this topic is so important, specifically for homeowners, right? Because there's so many reasons why someone should have an estate plan, and some of the things that an estate plan actually helps them avoid and protect them from. So thanks for making the time. Let's dive right into it. Tell us, what are some of the top 10 reasons every homeowner needs an estate plan?
Okay, well, we'll get into that. And, I do want to just reinforce what you just said, that it's so important for people to have the information, because that's how you make the right decisions. And these decisions that you make about how you own your home or what you do with what you put on title can have really good or bad financial consequences. So let's get into what you need to know about estate planning. Okay.
Wonderful. Well, I look forward to it. I know that many of my clients often hear of the word estate planning or living trust, but they just don't understand the concept. So I think that today's presentation is one of those that you'll want to rewatch over and over again. And if you have questions, definitely raise your hand, because it's a very, very important topic.
Okay. So just to let you know what an estate plan is, it's a package of documents, right? It includes the living trust. It also includes a financial and medical power of attorney, which we will talk about as we go through this. The most important benefit is avoiding the probate process. So probate is the court process. It
Right.
kind of is the same thing as trust administration, but it happens when someone doesn't have a trust. Now, there's a common misperception that people who have a will don't need probate, but that's not true. If you have a will, it goes through probate. It needs to be
Right.
confirmed by the court. But if you have a trust, that's what avoids probate.
Well, I understand that having a will would be considered in court, but it gives you some directive as to how you want some of your assets distributed that you leave to your heirs. But like you mentioned before, it still goes through probate.
Yes.
Now, why is it that we need to avoid probate? I mean, in terms of cost, time, tell us a little bit about why avoiding probate is important for a homeowner.
Okay. So first of all, the number one reason that people know about, I think, is the cost, right? So you're talking about legal fees, and I would say that they're generally between $12,000 to $15,000, maybe more, depending on the size of the estate, of the value of the property in the probate, right? You would double that, though, because not only does the probate get that fee, the probate administrator, who is the person appointed by the probate court, they also get the same fee. So now you're talking about maybe $30,000, right? You add on to that another $5,000 to $10,000 in court expenses. And these are expenses that cannot be avoided. So it's the cost of filing a petition in court. It's the cost of publishing in the newspaper. There will be a bond that's basically insurance. There will be a court-appointed referee to appraise the value of the property. And, there's just additional expenses that add up. But the most important is the creditors that come in through probate. Okay. So your number one that you can avoid very easily with an estate plan is your Medi-Cal creditor, right? So that's the Department of Healthcare Services. Anyone who uses Medi-Cal to have the state pay for their assisted living at the end of life, that is reimbursed after death from the probate property. Okay. But if you have a trust, the law actually says, and the law was changed back in 2017 to protect the homeowners. If you put your property in a trust, there is no need for that to pay that back, right? There's no creditor, there's no reimbursement.
I'm glad you mentioned that, because, in our community, specifically the Latino communities, right? Many of them are retirees. My mom's already retired. She has a living trust, thankfully, that we helped her build out about 10 years ago. But
Perfect.
a lot of Latino families tend to think that if they transfer the property to a son or daughter in order to qualify for Medi-Cal, and if they pass on, that Medi-Cal won't go after their property. Well, certainly that could be true because the properties might be in the name of the son or their daughter, but I've heard some horror stories about children removing all those assets or taking over those assets that the parents built over time and kind of leaving them hanging dry. So
Yeah.
can you share with us maybe some examples that along that lines in terms
Yeah.
of transferring property to some of
Okay.
the siblings?
Well, even before that, I'm going to tell you about a lady that she passed on. So I helped the family through the probate process. She had developed dementia and went into assisted living. She was in assisted living for 10 years on Medi-Cal.
Wow.
So Medi-Cal came back and their lien was like almost $300,000. So at the end of the probate, the family got $30,000 after all of the expenses. So that's an extreme example, for most of us.
But it's a good example because I think that people don't know. They still think that Medi-Cal is going to go after their assets when they pass on, but they're not aware of this new law that came out in 2017, like you mentioned, that by putting your property in a living trust, it would eliminate the ability for Medi-Cal to go after the estate or the estate in terms of what they owe the Medi-Cal when it's in a living trust. So that's, if anything at all, that should be the number one reason why you need an estate plan.
Yes. And I'm not here to give like specific legal advice. I just want to kind of make that clear. We can always schedule a consultation, or, you can come attend another presentation and ask detailed questions at my office about, estate planning and the tax consequences and the creditor consequences. Another thing that I didn't mention, aside from the Department of Healthcare Services, creditors can also make a claim in probate, and the judge will order that they be paid, right? They just will have to be paid before any of the legal heirs get any money out of that probate. But with a trust,
money left over in the estate from what the estate value might be, right?
Yes. After, mortgage, after all the other expenses, the creditor money comes out of that pot of money before the heirs get anything, right? So these, I'm talking now about like your credit card debt, medical bills, ambulance bills at the end of life, all these kind of things that can come back and they will make a claim to be repaid. But with a trust, now you have a trustee in charge of the bank account, and the trustee can choose what gets paid. And I advise my clients to, for the trustee to send that creditor a letter saying this person is deceased. The person who owes you money is no longer, living. There's not going to be a probate, and there's no estate to, for this claim to be paid. Correct. They generally go away. I was a trustee for my great aunt, and that's how I handled it. So I didn't pay off any of her credit cards. The only creditor that came back to me was Sparkless Water. They wanted their $35.
Oh, wow. And you would think, right? A small little creditor.
Yeah. But, they didn't get paid either because you don't have to, right? With a trust, you don't have to. But with probate, all of that is open and transparent. The judge knows what money there is, and the judge will order that all of those creditors be paid. Okay.
One of the other things about avoiding probate too is the length of time it takes, right, to go through probate. Typically, how long does it take for the court?
It takes about a year. And that's an efficient probate. Like the minimum would probably be, 10 to 11 months. That's the most efficient probate we can do is 10 to 11 months because there's just waiting periods. You file a petition, you got to wait for the hearing. There's just statutory periods that have to elapse before we could close out the estate. And sometimes probates last several years. That's if the family is not ready to sell property. They need time to clean it up and move out. Or if they start fighting over things, probates can continue on. I'm still dealing with some that I opened in 2021. But just a handful, because for the most part, we try to get them done within that year. And other counties, that's LA County. We can do it in a year. In San Bernardino, in Riverside, in Orange County, all of those counties, the timeline's even longer. So it's just not something we can control. It's very lengthy. So that means you sell the house and, if you're living there, you have to move out, but you don't get the benefit of having the money from the sale of the house until way later on.
Wow.
Yeah.
Well, for me, avoiding probate and everything that's attached to that is probably the best reason, if not the number one reason.
Yeah.
So let's move on. And what's another reason why estate planning is important?
Okay, so taxes, I want to talk about what you had said. I'm going to kind of go back to your question about, like, when family transfers ownership to children, they add people on title, because this has, I know you were kind of leaning towards talking about like terrible consequences of family taking over the home, and I can talk about that for days. But
Right.
mainly, the worst and most terrible consequence can be capital gains taxes.
Right.
Okay. So and this is a bit, nerdy, a bit complicated, but, so, I mean, the number one reason why to not put a child on the home is because then you give up control, right?
Right.
And you no longer are the sole owner of that
Let me, let,
property.
let me tell you something, you guys.
Yeah.
Control of your property is absolutely important.
Yes.
My mom's neighbor across the street, her dad and her mom had transferred the property to the eldest daughter for whatever reason. I don't understand why. So the dad passes away, and all of a sudden, the daughter decides that she wants to sell the property from under her mom's house, from under her mom's feet. She took all the equity and kicked her mom out and sold the property without her consent. And guess what? She didn't need to have her consent because all the ownership, the control of the property, she had given her to the daughter. So I know it's a horrible story, but the truth is that when there's money involved, people change. So
Yes.
that's just my story. I'm sure Liz has many more other stories.
Oh yeah, I've heard of a lot of those similar stories. Sometimes it's the grandchild and then they put grandma in a home, right?
Mhm.
So it's just, it's that lack of control. Sometimes the better thing, sometimes the reason people get put on property title is not necessarily just to avoid probate, but it's also to get a loan, right? I see that a lot, that they refinance and they need another income, so they put a child on property. But,
Yes.
there are a lot of good options with reverse mortgages these days. I know back in the day, it was a bit of a Wild West, and, some of them were really expensive, but, they are more regulated now, and hopefully they will
Yes.
continue to be regulated and even more tightly regulated so that, older folks won't get taken advantage of. But that is a way to get money out of the property. You can do it, with like a homeowner, like a line of credit, right?
Right.
You can borrow that way, or you can get a lump sum. So there are other ways than adding children to title.
Right. And I'm super glad that you mentioned that, because as of this year, this last 6 months, I probably helped 3 families, 3 specific clients of mine that were already in retirement age. One of them is my mother, right? Where look, their Social Security income is about $1,000, maybe $1,100 a month, right? Their expenses to live are quite a bit more than that. And they have what we call their equity rich but cash poor.
Right.
So the reverse mortgage has been a really good tool to help them. One of them was to do exactly that, was to get a lump sum from their equity, so they had a little bit more money in their reserves. And they don't, there's some other benefits to a reverse mortgage, but now they still have control of the property. The property is still in the living trust, right? So they've got some protections, and they're able to financially get ahead because of that reverse mortgage. My other client, I helped her sell a property. She was in a larger 3-bedroom, 2-bath. She downsized to a 2-bedroom, 1-bath. She took all her equity, she put it back in the home, kept some cash, and now she's living, with the reverse mortgage, protecting her assets, and she still has control, and she's leaving, her estate to her only son. She only has one son, but she was able to do that. So, to your point, reverse mortgages have changed over the years. They're a lot more regulated today than they were when they first came out. You're right; it was more like the Wild West back then, and I think the consumer is starting to educate themselves a little bit and are seeing the benefits of reverse mortgage. So thanks for bringing that up.
Yes. I mean, it gives you a lot of flexibility. You can fix up the house, or, have some money and not be worried. If you need, caregivers, all that can be paid with reverse mortgage.
Correct.
But, back to the adding children to title, another bad consequence, not just, people think, oh, my child would never do that to me. They will never kick me out. And maybe that's true, right? But they could have bad decisions on their part. They can get in a horrible terrible accident where they're sued,
Correct.
and then that home is now at risk, or they could get divorced, right? And the spouse, the future ex-spouse, right,
Mhm.
could want a piece of that property, especially,
Correct.
and may have rights to it, right?
Correct.
So there's a lot of things that, we just lose control when we add people to title. But the worst consequence is the capital gains tax. So by adding someone to title, you're now giving them the property. It's a gift. It becomes a gift, right?
Right.
So what you gift along with that is the tax basis. So
Mhm.
that means, in a nutshell, it just means that when you purchase your house, that becomes your tax basis, right? Whatever you buy your house for, say it's $100,000, that's your tax basis. If you sell the house, you have to report the gain from the
Right.
sale of that house to the IRS, and typically there's gain, right, Hector?
Right.
I mean, most houses acquire equity in a short period of time. So anyway, there are some deductions you could take, exemptions, but the bottom line is if you sell the house, you have to pay tax on the gain. And so say you sell the house for $800,000, you bought it for $100,000, you're paying tax on $700,000, and that could be at 30%. So I mean, I'm not going to do the math because I
But
can't
it's
do
a
the math.
chunk.
But,
It's a
it
chunk.
is definitely a chunk. And for sure, that can totally be avoided by not gifting the property, but by allowing someone to inherit the property instead. Because when someone inherits their property, a piece of property, the tax basis on that property is now the date of inheritance, right?
Correct.
So the date of death, and that value will be, at the higher level, it'll be current value at that time. And then if the property is held for a longer period, there may be a slight gain. So there could be some tax, when it's eventually sold. But if it's sold in fairly short order, there's really going to be minimal gain that has to be reported. So all of that gets to stay with the family. So we're talking
Fantastic.
like, 6 figures, right?
Oh,
Usually.
absolutely. Reducing,
Yeah.
protecting
Just in
against
taxes.
tax
Right.
reduction is so important. So yes, good point.
Yes. One more comment on taxes, and this is a quickie, but property taxes also go up when you add people to title, right? If you
Yes.
change ownership in any way, Prop 13, which is our property tax law, the law says that your property tax is now reassessed to the
Mhm.
market value of, the
Of the
new
property.
ownership structure, right?
Correct.
So
Correct.
sometimes that doesn't change when people are added as joint tenants, but it definitely can have consequences. And I have that conversation with my living trust clients all the time. If they've got children on title, now how are we going to take them off without jeopardizing their property taxes?
Correct.
So,
Correct.
that's opening, a can of worms that can be hard to put them back in, right?
Right. And it
So
can be avoided by having an estate plan. So
yes, absolutely. Absolutely.
wonderful.
Yes.
So what's another reason why it's important to have an estate plan?
Well, we're going to talk about minor children, right? So a lot of my clients are, my age or older, right? They're seniors, they're people who are like planning for the eventual transition of ownership of property, right?
Right.
Because, to them, in their mind, that's how they take care of things. And really that's the responsible thing to do.
Right.
By not setting things in place, you've got, I have a friend who says that's child abuse. That's child abuse. You're leaving them with big problems. But what I'm trying to say here is that even younger families, right? Even for younger families, it's
Yes.
appropriate to start setting that up so that it allows them to have a plan in place if the worst does happen, right?
Right.
Because none of us ever know the future. We cannot, like, with
Well,
100% certainty predict what would happen.
well, they say that tomorrow isn't promised, right? But, you have young families, in their 40s or 50s that have had homes now for 10, 15 years, or even 5 years, or even a year. They have children, they have grandchildren. And like I said, tomorrow is never promised. There could be a terrible tragedy. And we hear them on the news all the time. We always think, oh, that would never happen to us. But then lo and behold, it does happen to us. So having an estate plan will allow you to, give directive in your estate plan, in your living trust, on how to protect those children. So it happens all the time.
Yes. So I'll give you a couple of examples, right? So first of all, if there is no trust, if no guardian is appointed, what happens is if both parents are deceased, now someone has to go petition to the probate court to get a guardianship, right, over those children. That would allow them to manage any inheritance that they have, any money, and do things such as, like, take them to the doctor or enroll them in school. I mean, the basic things that we need to do for our children, right? So you want to appoint guardians, or you still have, I'll take that back. You still have to go through the court. A guardian cannot just be appointed by a parent. There's still an appointment process through the court. But having that nomination ensures that you've got the right person, and then you can have a conversation with that person that you nominate so that they're prepared in case that worst case scenario does come through, right? So there's a plan in place. And the other thing is when money is inherited by children, they can't own it. A child under age 18 can't own money, right? They can't receive money. So then what happens is a lot of times that money goes into a custodial account, and whoever is the custodian can use that money for the child. But the problem is, if you're not appointing who that custodian is, it can be someone who's irresponsible and can deplete those funds before the child, has a chance to use that money for college or to buy a car, or for whatever their needs are. So it's just about setting it up the right way according to your wishes, rather than leaving it to chance. And the other thing you can do with a trust is that in a trust you can designate what age the money goes to the child, right? So if it's a life insurance policy or a bank account, they're going to get it at age 18, assuming there's money left at that time, right? They're going to get their lump sum at age 18. I don't know about you, what you think, but my children were really not, mature enough to handle a huge lump sum. They didn't get it, obviously, but, they wouldn't have been able to at age 18. So with a trust,
I agree with you.
Yeah.
I agree with you. I think, 18-year-olds, they're just maturing. They're still children in my mind. And I've heard of stipulations, and I'm sure maybe you've had clients that will make stipulations in terms of, hey, I want to distribute this money in my absence until they're at least 25 years old. Or if maybe some of them ask them, hey, they need to go to college and have a degree, or there's certain circumstances that you can put in your directives that will at least give an opportunity to your children to mature from the age of 18 to the age of 25 in most cases, so that when they do receive this lump sum, they don't go and just blow it insanely, right? Because, I mean, what 18-year-old with, I have a personal nephew of mine. He's 19 now. Unfortunately, his mom passed away about a year and a half ago of a heart attack. And he received a lump sum of, I don't know how much money. And we were wondering, like, what's going on? Why is he spending? Where's all this money coming from? Obviously, it was a private matter, but we came to find out that he did receive that money. And we had to counsel him and teach him, like, hey, that money's not going to be around forever. Maybe you should do X, Y, and Z. Let's get you into a property. Let's put some money away in a CD. Let's protect you for your future, because you're going to run through this money quickly. So to your point, I don't think any 18 or 19-year-old, any young adult would be ready to manage large lumps of money.
Right. Yes. So, parents can set reasonable restrictions. They can set, ages. You can say, 1/3 at age 21, 1/3 when you graduate from college, 1/3, at whatever age. So it can be, portioned out so that it's and the parent gets to decide. I'm not saying what it should be. I'm saying the parent gets to decide what it should be.
Correct. And it serves them well. It serves the kids well. They may want it all up front, but there's reasons why those stipulations are created. And I think it's a good opportunity to you as a parent to have that control through your estate plan.
Yep.
Thanks for sharing with that on the protecting minor children. Let's go on and find out what another important thing about having an estate plan, and that is controlling distribution of assets, right?
Yes.
Tell us a little bit about that, and what does that mean?
Well, it's kind of the same thing about, like when we're talking about minor children, the only difference is now we're just talking about the adults, right? And if you want property to be distributed immediately on death, then you can specify who would get what. Now, you can do the same thing with a will that goes through the probate court, but a trust, that's the purpose of the trust, is to identify how property should be distributed, in what percentages, if there's anything specific, such as the business where you want a particular child to operate that business, on an ongoing basis, or if you want to share the stock, or, it can all be done very, if it's in writing, that's when it matters. I have a trust client, we're doing his trust administration, and he wanted to sell the house. There's 2 houses in the trust. He wanted to sell one of them to a brother and sell another one to another family member at less than market value, because that's what his mom wanted, right? She told him what her wishes were, but her wishes were not written down in the trust. And so he's violating his fiduciary duty if he doesn't follow if he's not fair to everyone. And so, we have to make sure that everyone is treated fairly. So that's what happens with trust administration. And if it's in writing, then your trustee is obligated to follow those wishes. And we can even do things like, set up an appendix where you write down like specific personal property, like photos or jewelry, or, a car, or things that have personal value, and you want it to go to a specific person, grandchild, or even a charity. All of those things can be designated if it's in writing in the trust.
You bring up a good point, and I think it's good to note that having an estate plan doesn't necessarily revolve around having a real estate property or real estate assets. It could be personal property too. It could be a car, jewelry, things of that nature, bank accounts, life insurance policies, things of that nature, anything that has a value. I think estate planning is more prevalent when you do have real estate, because it's probably the largest piece of asset that you own. So sometimes people don't think of all those things, and ensuring that your wishes are honored when you pass on and you leave your heirs with your estate, I think is probably the best peace of mind that someone can have.
Right. I think so too.
Well, let's move on. Let's see. What's another reason why it's so important to have an estate plan?
Okay. So with incapacity, this is now what we're talking about, is if the homeowner or the property owner is unable to make their own financial decisions, right? So this, the most common, you would think about dementia or Alzheimer's, right? And that's a gradual, decline into actual incapacity. So, so the way the law works with the financial power of attorney is, if you have it in writing and you designate, it has to be notarized, it has to have particular language, but you can designate someone to manage your financial affairs. If the situation comes up that you either decline into incapacity, or if there's, an accident and it's, something that's more sudden. But once the paperwork is in place, the way we typically set it up is so that it's not in effect until it's actually needed, until the principal of the document, the one who's signing it, until they are actually incapacitated. Until that time, it's just a document that's part of the estate plan in the binder, and it's there for when it needs to happen. And so, as I had mentioned earlier with guardianships, no one else a non-owner cannot come in and manage your bank account, even if they're your best friend, or, they're your mom or your dad or your, sibling or child. No one else can come in and go to the bank and say, okay, this person is in a coma, I need to manage their bank account. The bank's going to send them away, right?
Correct.
And if the power of attorney document isn't signed in advance of that, then the only option that person has is to go through the probate court and get a conservatorship. Okay. Correct. So that is very expensive. My office has done a few of them, but we don't do them anymore because they're just so labor intensive. And so I refer them to, other attorneys who charge, $1,500 or $5,000, retainer up front. That'll just get you to the first hearing.
Right.
Yeah. So it's so, easily avoidable by just having a simple financial power of attorney document in place.
So I have a story that I'd like to share. We recently had a loss of a family member in my wife's family. And there was no estate plan. The property, unfortunately, is not in a living trust. So the son's going to have to go through probate. but there was a situation where he completely went through all like, I mean, she was in the medical care, and there was really no one who advocated for her. No one had a say in it because it was her only son. There wasn't like a medical directive signed. And so, you would think that a son or daughter is going to do right by their parent. I know firsthand that doesn't happen. And so incapacity planning is absolutely important. It doesn't have to be a child, it doesn't have to be a daughter or a son. It needs to be someone that you trust, right? And it's just guardianship over your incapacity, whether you're in a coma or you have dementia or Alzheimer's, or your family member, your loved one medical condition has fallen to a point where they can't care for themselves. Definitely think about that, because like I said, it doesn't have to be a son or a daughter, but certainly has to be someone that you trust. So just keep that in mind.
That's correct. All of that is so true. And like I say, it's a simple document to prepare. I'm talking about the financial power of attorney, and we will talk about the medical power of attorney also. So it's a different document, but also just as important.
But it's part of the incapacity planning, right? The financial, and the medical directive, what we would call it, right? Right. Wonderful. Wonderful. All right. What's another reason why we should have an estate plan?
Well, I guess this is somewhat about the same thing, right? We're taking care of our children, we're taking care of our beneficiaries to protect their assets in the most common sense and the best way, right? So that's really what we're talking about when we're talking about estate planning is to make sure that the children are taken care of and that the property is owned by a trust. So that's how the trust works, right? Is the trust becomes the owner of property, and the trustee is named in the trust, and then that trustee changes over time as the original trustees pass on. Your successor steps in, takes over, manages the trust assets, right? And then distributes them according to what the language is that's in the trust. But that language is like super important. As I kind of mentioned, you can designate however specific you want to be, or you can set it up very generically, right? To be just, in percentages or proportions or whatever. And then the one thing that's also very important to know is to make sure that that property is transferred to the trust, right? I've had so many people come to me and they bring me their trust documents. One time I had someone bring me a document from LegalZoom that she had gotten, and it was in a very fancy binder. It was beautiful, but it wasn't even signed because she didn't know she had to get it notarized, right? So that's kind of the downside of the do-it-yourself, right? You want to just make sure that everything is followed through. That's what we do here in our office, is we make sure that all of the property that should belong to the trust is actually transferred. And I'm talking about real property. We do the deeds and we get them recorded. Bank accounts and other financials, that we leave that to the responsibility of the clients.
And I'm glad that you mentioned LegalZoom and some other self-help platforms that you could potentially create your own living trust. But the truth is that most people don't realize that there's so many important parts to a living trust or an estate plan. And I can't emphasize enough how important it is to invest in your future, in your children's future, in your heirs' future, because, even if it costs you, I'm not saying it costs, $5,000-$6,000, but it's going to cost you a couple $1,000s to create an estate plan. And depending on how many assets you have and what your directives are, it could be more. But let me tell you, you won't be disappointed. It'll be money well spent versus trying to do it on LegalZoom or other self-help platforms where, like she just mentioned, it wasn't even signed. And most people don't know that you actually need to fund what we call fund the trust, which means is to transfer the ownership of the property into the trust, right? So that the trust can then protect the asset. So, please, get a consultation. You won't be disappointed. And believe me, it's going to be to protect your future, your beneficiaries, and to protect your assets. So don't be afraid. That's the last thing you should do, is be afraid. Educate yourself. This is why we're bringing this to you, giving you some free information, so that if you want a further consultation, we can make an arrangement for you and to meet with Liz and her staff to define and to figure out what really needs to be in your estate plan as well.
Okay. All right, let's move on to the next
All
one.
right. So one of the main reasons, and I alluded to a couple of stories that I shared with you, right? My mom's neighbor across the street, one, and two, my wife's aunt's family that just went through a situation with the loss of their mom. Biggest and most important thing in my mind is avoiding family disputes. Like, that's a huge headache. Tell me, why is that the case, Liz? Tell me a little bit about that. Maybe share some examples that you might have.
Okay, so definitely when you're in probate, it's a lot easier to object to things that your probate administrator is doing. All you have to do is show up. And nowadays, it's actually online, so you don't even have to leave your house. You just have to like log into the computer and make sure that you're registered to attend a hearing, and then you can show up and object to, and what that does, it just stalls everything. So, some families, they just can't get along. If that's your family, then they may end up spending a lot more on legal fees than I think is really truly necessary. I don't do litigation. I don't like doing litigation. I just do probates, which have a statutory fee based on the value of the property. But when you get into litigation, now you're talking about, $4 or $5, $6, $700 per hour attorney's fees, and it just, when you have a trust, it's harder to dispute the trust because, first of all, everything has to be notarized, and so it's all in writing, and everything's pretty straightforward in the trust. And then to dispute any of that, you actually you have to hire a lawyer up front. First of all, there's deadlines. There's like 180-day deadlines if you're going to dispute the validity of the trust. It just costs a lot more money for the person that wants to object to actually go to court and do that. And I don't know, again, I don't do litigation, so I don't know how likely an attorney is to take a case where, they're not likely to win because the trust is pretty straightforward and signed and everything.
Pretty solid too.
Yeah. And also, it's I don't know. It's just, there's just more rules, right? When it comes to disputing a trust. So the trustee, we mentioned this before, the trustee has to be someone that you do trust. You want them to be somebody that's like responsible. They're going to do the right thing. They're going to, follow the rules. They're going to take action, right? Like by going to the bank or hiring a realtor and getting things handled. And as long as you're a trustee, you pick the right person and they're doing that, then, you're really going to avoid these kind of like petty disputes, right? They're not going to be able to just go to court and dispute anything that, that they want to, just to delay things. Now, there's a caveat that some families probably should go through probate, right? If there's no one that's trustworthy and they're all going to fight over everything, then just go to probate. Don't do a trust. Go to probate, and then the judge will oversee things. And it will take more time, but eventually things will follow the law, right? It will be a lot more
expensive. The point of having an estate plan is to avoid probate, number one, because we know it's costly and it's lengthy. But it also, the estate plan or the living trust helps avoids disputes because, these are things that your parents, your loved one took the time to designate to a specific person for their own personal reasons that have nothing to do with the feelings of everyone else. And I think that's kind of the challenge, is that people's feelings get hurt, but it's not something that the person or the trustee is responsible for. So they're just carrying out the instructions that your mom or dad or your loved one left behind to make sure that you receive those items that they felt were important to you or important to them for you to have. So it does avoid family disputes. And like you said, there's families that don't even talk to each other. I know families myself that, hey, have you talked to your brother? Oh man, I haven't heard from him in a couple years, right? Like luckily I'm not one of those families, but I know there's families out there. And so obviously avoiding family disputes, even in the worst case scenarios where they don't talk to each other or get along, it goes a long way. So that's, in my opinion, one of the top 10 reasons why having an estate plan is key.
Yes, absolutely.
Well, let's move on. One of the other reasons that it's important to have an estate plan is business succession. Talk to us a little bit about that. What does that mean? And I know there's many homeowners that maybe own businesses, dry cleaners, restaurants, things of that nature. So does it have to do with this kind of business succession?
Yes, yes, it does. Okay, so a lot of us own small businesses. I'm an example of that. I own
Right.
my own business, right? So when you have a business as a DBA, it's really your own personal property, right?
Right.
And or if you have an LLC or a corporation, then the way those work is you transfer the ownership to the trust, or you designate the trustee to have, power over those businesses. For the small businesses, there's not a lot of investment in legal documents, right?
Right.
It's kind of rare unless you have like a partnership or other business members, other owners that you're co-owning with, and you want to designate what are the rights and responsibilities and what happens when one of them dies, right?
Right.
But for a lot of small businesses, you don't have that kind of documentation. It's just you're busy running the business.
Right.
It's a day-to-day thing about getting those bills paid and providing the product or service.
Correct.
So what the trust can do is instead of having a legal document on the business side, you're authorizing the trustee to then kind of like take over the business as far as like the assets, and if it needs to be wound down and closed up, then the trustee has the authority to do that, or they could sell the assets or sell the stock. They then have the power to do it. You have a transition, right?
Correct.
Whereas if you have a corporation and you're the only owner of the corporation, you're on the Secretary of State website, it only has like the one name as the president, secretary, and treasurer. You don't have anybody that's authorized to manage that company if that one person is no longer around. And
Correct.
just like with a home, you can't sell a home, you can't sell a business if you don't have the owner to sign the paperwork to do that,
Correct.
right?
Correct.
So that's the importance of business succession. You can designate who's going to receive it. You can designate who's going to operate it. It can just be part of the general assets that are divided up by a percentage. So you have 4 kids, they get 25% each. That's all very easy enough to do. And then it's just one simple document to assign the rights to the trust.
Fantastic.
Yeah.
Fantastic. That's good to know, because there's a lot of, especially in the minority assets or classes, pardon me, you have a lot of self-employed people, whether they have mechanic shops or cleaners, bakeries, restaurants, like myself, who's self-employed as well. It gives them a directive on how to be able to, who's going to take control of the business, who's going to run the business, does it need to be sold, who's going to follow your directives. And so many people should consider the importance of having an estate plan if they do have a business that they're currently running too.
Yes.
And finally, and not the least of the reasons why you should have an estate plan, and we alluded to that a couple times during our conversation already, is healthcare decisions. Tell us a little bit about that, and why is that so important in today's day and age, especially now that we're transitioning on here in the next 20 years to probably the biggest transfer of property from our baby boomers into the new generations.
Yes. Well, we saw this with COVID, how difficult it can be to make decisions about a person who's there in the hospital, and especially if they're on life support. And my kids laugh at me because I watch too much 911. So I see, I see all the different ways people can get hurt and
Sure.
in the hospital. So things do happen. Once you have that healthcare document, it allows you to state in there what your specific wishes are. Would you want to be on life support for a prolonged period of time? Would you want to have that removed, after a reasonable amount of time, if you feel like if the doctors advise that there's not likely to be a recovery? There's things like organ donation. I talked to a lot of people, and some have very strong feelings of one way or the other. No, don't donate my organs because then they'll just kill me early, or do donate my organs because I want my body to increase, research and education. So, there's a lot of different various opinions.
Right.
And so for each person, they can put that in writing, and then their body will be handled in the way that they want it to be. And also that applies to like post death handling of remains, whether that's cremation or burial or different things, to be respectful of what the person's wishes are as opposed to what the families are. I have a funny story. Well, it's not so funny. I'm not laughing about it, but I had a situation where a man had died, and he had been married to a wife that had died before him, but he
Mhm.
was also married to a wife that was still living. And
Wow.
so there was a little bit of a dispute over who had the rights to his burial. And
Estate. Right.
um, he was still legally married, but had been in another relationship for so many years that that person's family thought that they had legal rights.
Wow.
So we worked it all out. I mean, at the end of the day, we got it done, but it's just important. It's super helpful if things are if people know the situation and know what the wishes are.
And I appreciate that because I had never considered a healthcare directive to have to do anything with my personal body, even in post death, right? Once I die.
Yeah.
But certainly I can see how these unique examples of stories can apply, right? So if anything at all, I've shared a few stories about, how a loved one treats someone who's in the hospital, and if there is no medical directive and they're the only like maybe representative that they have because it's the older son or the daughter, it's hard to make decisions when you don't have a healthcare directive, whether
Right.
you're in life, whether the way you want to be treated, like as Liz mentioned, in a coma, if there's no prognosis of improvement, you can leave a directive there. And in post life, like you can tell, or you can leave delineated in your estate plan how you wish to be handled, if you will, once you pass on to rest. So thank you for bringing that to our awareness. That's something that I had never considered in terms of someone having rights to my remains after I pass on. So thank you for sharing that.
Yeah, I think that it's super important for every adult, whether they own any property or not. They should have the financial and those medical power of attorney documents. I thought there was one more slide, but if not, I can just talk generally about, let's see, is there a
Oh yeah,
10th
there's support
reason?
for spouse.
Yes, yes. Okay, so the 10th issue is for married couples and also for non-married couples, right? People who own property together, there can be really drastic consequences if only one of the partners owns the property and there's nothing in writing to care for the surviving spouse. Okay, that's the kind of thing that happens. Sometimes it's a second marriage, and that property, the home, was maybe the family home from the marriage, and should go to the children of the first marriage, right?
Correct.
Sometimes that's the best situation. Um, Other times, the spouse may say, "Well, I've been with this second spouse for so many years. That's who I want to take care of, at the expense more of the children who are maybe more successful and they're fine, they're stable." So it's really a personal choice, but if it's not in writing, then the law kind of makes that choice for them. And when there's a marriage, like a legal marriage, the law allows for the spouse to receive a portion of the property.
Right.
But if there's no marriage, and this is fairly common, right? And I work with a lot of same-sex couples and unmarried partners. It's Pride Month, so um, want to celebrate all kinds of families and couples,
Sure.
um, but just want
Absolutely.
to focus that really it's the same-sex couples that sometimes just don't plan, right?
Right.
And without that marriage license, there are no rights. There are no rights to do anything with the body, as we had just talked
Mhm.
about, like the burial or cremation. There's no rights to inherit from the person, from the partner, unless
From the
there's
estate.
something in writing. Um, and I've just seen a few of those, that come out tragically. And we tried to do a trust for one man who had waited too long. And then, he was in like the very end stage of cancer and just
Wow.
couldn't get everything signed before the
In
end.
time.
And so then his life partner was left with nothing that they had worked for together for so many years.
And
So
it's important because I think that there's a lot of cases that we could probably reference where that's the case, right? There's no legal marriage license. They don't have any legal right to the estate. Even after spending 30, 40, 50 years with that person. I know that there's some couples that are unmarried that choose to stay unmarried.
yeah,
But when it comes down to it, they don't realize that unless they have a legal document that says that they're married, they may not have any inheritance to the estate whatsoever. So again, if there is any other reason why, if you're in a situation when you're in a same-sex relationship, or you have a life partner, it's absolutely important that you consult with an estate attorney to figure out what steps you need to take to protect each other from loss or of those what ifs should happen, right? So take the time. I think it's super important. For
yes.
sure.
And I'm talking about like the situation where only one of the partners is the owner of the property.
Correct.
So there's other ways, there's joint tenancy or whatever. But, at the end of the day, when both are gone, that property will go through probate if there's nothing in writing.
Correct. And we have definitely spent, a better part of an hour, close to an hour, talking about the top 10 reasons as to why you should have an estate plan. I want to personally thank Liz for making the time to share some of her insights. Obviously, there's a lot more information that she can share with you, and it's going to depend on every family's case-by-case basis, what their needs are, how many children they have, how many real estate assets you own, if you own businesses or not. So many things that we discussed, and I think at the very least, you should book a consultation with Liz and her staff or an estate attorney of your choice. Obviously, getting an estate plan is super important, whether you own real estate or not, or whether you have a common law husband or wife or not, or if you're in a same-sex marriage, or if you're in a long-term life partner relationship and you have assets. It's definitely worth the conversation. Don't overlook it. It's very, very important. You want to avoid probate at all costs, and then take advantage of some of the other 9 or 10 items that we discussed as well. So I don't see anyone that's online right now. I think we've got a couple of people that are watching. You guys are welcome to make some comments on Facebook or maybe ask some questions. Definitely do so. And if not, please feel free to text me. Because you've watched this on Facebook and on our YouTube and you spent the better of almost an hour with us, we're offering a $200 discount off an estate plan with Liz Apodaca and her staff. So all you need to do is, send me a text message that says estate plan, and I'll be sure to get in touch with you and get you guys on her calendar so she can have a consultation. And just before we close out, Liz, tell us a little bit about your company, My Attorney LA, your staff, and how you handle clients as they come in.
Okay, thank you. So I'm one of the main attorneys here. I handled like the probate side of things. So that's really my area of practice is dealing with estates where there is no documents set up or maybe just a will. And then we have Suzanne Gonzalez. She's also very experienced. She's been an attorney for about 20 years, and she handles the estate planning side of things. Both of us do presentations, group presentations at our office here. And if anyone attends those, we would give them that same $200 discount for attending a presentation, right? And that's a chance to come in person and ask very specific questions. Those are all free. And then as far as the trusts themselves, the price range is around $2,000 to $2,500, depending on, the number of discounts you've got. And there can be a little bit more if there's additional real property to transfer into the trust. But all of those fees that I'm talking about do include your notary. They include the transfer fees that are paid to the real estate, service. So when you leave the office, you have a nice binder full of your own original trust documents, and we also put them on a flash drive. So and we take care of the funding for the real property.
Fantastic. I mean, as you see, there's definitely all different aspects of the importance of having an estate plan, different um, things that go in an estate plan. And so I think at the very least, the consultation would benefit you just to make sure that you're aware, right? I think awareness is most important because that way you're able to make a decision that's going to benefit you and your family. And believe me, those 2,000, 2,500, whatever it is that you're going to spend on an estate plan will be money well spent. Believe me, you don't want to be caught
Absolutely.
without an estate plan or a living trust and leave your family or your assets and probate or at least in a bucket full of challenges. Do that up front. Plan your life out. Sit with an attorney. Sit with Liz Apodaca and her staff over at My Attorney LA and OC, and get started today. So, Liz, once again, I want to thank you for setting some time aside for us to kind of enlightening us with this amazing information. If you guys are thinking about maybe getting an estate plan or at least want to have a conversation with an attorney, with Liz or some of her staff members, please reach out. You can either email me or even text me. Like I said, send me a direct message on my number, 626-255-2783. Just put estate plan, and I'll be sure to put you in touch with Liz and her staff. So you can honor the $200 estate plan discount for being part of our presentation today, our podcast today. And I hope that everything works out for you. And Liz, again, thank you. I can't thank you enough. I look forward to educating more and more of my clients and bringing them to you because I truly believe in the power of an estate plan. So thank you, Liz, again.
My pleasure. Thank you so much, Hector.
My pleasure. All right, everyone. We'll see you next week. Thanks again for joining us on this week's podcast. My name is Hector Aguilar of eXp Realty, and I look forward to providing more valuable information in weeks to come. Take care, everyone, and thanks for joining us.